short 5-minute recess after the second case. The first case we have before us is Fair Insurance Rates in Monroe County Incorporated versus the Office of Insurance Regulation. Is appellant ready to proceed?
Yes, Your Honor.
You may.
May it please the Court, Sidney Bigham on behalf of the appellant, Firm Incorporated, and with me today is co-counsel Timothy Perry. We're with the law firm of Oertel, Fernandez, Bryant, and Atkinson. Good morning.
Good morning.
I'd like to reserve 5 minutes for rebuttal, please. On appeal today, Your Honors, is the Office of Insurance Regulation's denial of Firm's petition for formal administrative hearing under 120.569 and 120.571 of the Florida statutes. Now, the orders on appeal involve the orders subject to the petition involve final agency action by the Office of Insurance Regulation establishing insurance rates for the appellee Citizens Property Insurance Corporation. And for clarity, Citizens...
So if it's final agency action, how could it be subject to administrative review?
Under the APA, Your Honor, a final agency action is ripe for administrative review via a formal administrative proceeding.
I thought preliminary agency action was ripe for administrative review, culminating in final agency action that then goes to the appellate courts.
Your Honor, preliminary agency action is actually not yet ripe for administrative review. Agency action becomes preliminary when it's challenged by a petition for formal administrative proceeding. This is an example would be an environmental resource permit. The agency issues that permit. It's subject to challenge. It's rendered preliminary by the filing of that petition. It becomes a final order.
I thought it was rendered preliminary by virtue of the notice of, in your example, of a notice of intent to approve. Everything leading up to that is just free-form agency action that then becomes preliminary agency action once the agency says this is what we're going to do. That then gives right to an administrative proceeding that, depending upon whether there's disputed issues of fact it goes to no or not, that culminates in final agency action that then is subject to review. Is that not how the normal process works?
You're correct, Your Honor, and I think that we're talking about the same thing here. The orders that were entered by the Office of Insurance Regulation establishing citizens' rates or agency action that are subject to administrative review.
Except that the legislature specifically said it's a final order. How do we deal with that?
Your Honor, under the Administrative Procedure Act, a final order is defined specifically as an order that follows an administrative proceeding. It's not defined by Chapter 627 of the Insurance Code. That phrase needs to be construed under its plain meaning as referenced in the Administrative Procedure Act. These two sets of statutes.
So the way it would work then, if I'm understanding correctly, is the office would issue a final order as final order is intended to mean in the statute. Then there would be administrative proceedings at the conclusion of which they would issue another final order, but this time it would be a final order as defined in 120. Is that how it would?
Your Honor, I think that is a bit of a matter of semantics here. This is an order which...
But there would be another final order in your view, right?
Yes, Your Honor. Yes. And so, unlike with private insurers, OIR establishes the insurance rates for citizens, which I'll refer to as the corporation, as it's referred to under the insurance code. FIRM, which stands for Fair Insurance Rates in Monroe, is an association of Monroe County residents and business owners.
Let me ask you this, because it seems to me like you encapsulated the case with your first couple words there, unlike private insurers. As I understand the insurance, or I don't understand the insurance code, but as I understand a couple of distinctions in the insurance code, there's a specific procedure in 627.072 maybe, or maybe I have the statute wrong, that talks about private insurers using file and pay and file, or whatever those two distinctions are. But the bottom line is the statute treats those differently and specifically talks about this administrative review process being available, whereas in the statute governing citizens, it doesn't. Don't we have to give some significance to the fact that the legislature wanted it done a certain way for other insurers than it did for Citizens?
Absolutely, Your Honor. And these two sets of statutes, the APA and the Florida Insurance Code, can be read in harmony. And that's this court's, that's all of our obligation, is to try to read the statutes in harmony with one another. And I think you're correct, under subsection 627.351, sub 6, sub n, sub 1, that deals with Citizens Insurance Corporation. And the last sentence of sub n, sub 1 of that statute says, the corporation may not pursue an administrative challenge or judicial review of the final order of the office. Now, the plain meaning of that is that the corporation is restricted from seeking administrative review. The legislature knows how to say no one may seek administrative review, but that's not what they said. They said only the corporation is prohibited from seeking
Can
administrative review.
a policyholder take it out of Citizens context and put it in State Farm? Could I, as a policyholder, file an administrative petition for administrative hearing under the process in 627.062, where that a private insurer goes through and sets its rates? And again, I apologize. It's something a file and collect, or collect and file, or whatever. There's two ways they go about doing it that specifically sets forth opportunities for hearing. Could I, as a policyholder, interject myself in that process?
Your Honor, and I agree with you, the insurance code is not entirely clear. I think that a policyholder, in the context of a private insurance company, it's my understanding that OIR reviews rates of insurance companies. Now, there is a mechanism for policyholders to challenge rates as applied to them under the insurance code, and you'll find that under 627.351. However, as the agency has stated in our case, that's 627.371, subsection 1. Those are hearings on how rates have been applied to a specific policyholder. What we're talking about here is a petition for formal administrative hearing as a check on governmental action to ensure that the establishment of rates, not the application of those rates.
Right, but isn't that the point, though? I mean, as I understand that 627.062, if I've got my statute correct, that's the procedure that the agency uses to review and presumably, maybe I'm wrong, approve rates set by private insurers. And if what you're saying is a policyholder couldn't interject themselves in that process at the rate-making stage, why would it be any different for Citizens at the rate-making stage versus the application stage, which is the other statute you just talked about?
Well, Your Honor, I don't have precedent on how the policyholders would interact with private insurers at the rate-making stage, but I think the APA makes it abundantly clear that the orders of the Office of Insurance Regulation establishing citizens' rates are not exempt. Under subsections 80, 120.80, and 120.81, there's no exemption. In fact, OIR is listed under 120.80, subsection 9, and they are exempt only for certificates of authority, and they're only exempt for the limited purpose of certain deadlines under the APA that would apply.
Well, I
the
mean,
legislature knows how to exempt
let's
them.
try and take a 50,000-foot look at the whole process. The statute, which was amended after the major hurricane seasons of 04 and 05, provides for what seems to be a pretty accelerated annual review of citizens, correct?
Yes.
Every year they have to file.
That's correct, Your Honor.
All right. And every year the office has to adopt rates. For example, this set of rates, they cut some of the rates, as I recall, from 8.6 to 8.3. They adopted some of the other rates recommended by Citizens Wholesale. That process takes some time, I assume a couple months, and boom, the rates are established. Citizens proceeds to get those contracts out or apply those rates, forgetting for now the probable cause issue letter. And then in the wink of an eye, it's time for the new rates for the next year to come in. So the legislature says, citizens, you can't challenge whatever decisions OIR makes. If they cut your rate increase in half, you can't challenge it. Citizens, you can't increase by more than 10% a year. It's a streamlined, effective system that makes those rate changes every year. So how are we going to say, based on the fact that the legislature said, citizens, you don't even get to challenge it. Nobody's more substantially affected than citizens. You don't get to challenge it, that a policyholder or an organization like yours gets to come in, take it to a hearing. You're talking about a process that takes at least a year between going to the hearing, getting a recommended order, getting the final order, and then going on appeal. In fact, a process that could take multiple years, right?
Your Honor, I understand your concerns here, but there are...
Well, no, I'm saying, isn't that the way the system's supposed to work according to the way the statute is to be prompt, to be efficient, to be annual?
Your Honor, and I believe that the system can work that way under Chapter 120, affording substantially affected citizens, the public of the state, an opportunity to have a check. And 120 allows an administrative law judge to schedule as appropriate, to schedule the hearing, to schedule the proceedings as appropriate. Here, the rate orders were established in September 2016, not to become effective until February 1, 2017. It's quite a few months. Bid protests are accomplished in that amount of time as well.
Let me ask you, I know you're in your rebuttal time, but you did touch on the 627-371 process, which was, I think, the second part of, or I don't remember if it was a separate final order or it was a separate part of the final order on appeal, but I think you characterized it the same way that OIR did, is it really gets to an application of the rates rather than a backdoor way of being able to challenge the setting of the rates. Did I misunderstand the position you're taking or no?
No, Your Honor, you did not. To the extent that the parties are in agreement that that's a mechanism solely for challenging the application of the rates, we need Chapter 120 to be a check on the establishment of the rates to ensure that the agency complies with the law.
Okay, but on that statute, if I understand how that statute works, you're challenging the application. You go to the insurer and say, there's a problem, provide me some relief. The insurer says, here, citizen, says no or does nothing. Then you go to OIR and say, well, they did nothing. We want you to fix this problem. And the agency's making a probable cause determination, which is the point in time you want some sort of administrative hearing to challenge their probable cause determination. Is that where this is in the process?
Your Honor, again, we pursued that relief in an abundance of caution to ensure that we exhausted our administrative remedies. It wasn't entirely clear from a plain reading of the statute whether the only people who can pursue that type of proceeding are people who have actually had the rates applied. The rates were not applicable to us at the time we filed the petition. We maintained that cause of action in the petition in an abundance of caution. But I think the crucial matter here is that the APA affords firm the opportunity to challenge final agency action that substantially affected disputed issues of material fact exist. It alleges standing. All of those allegations must be taken as true. And for those reasons, it's a gross abuse of discretion for OIR to dismiss firm's petition out of hand without leave to amend in violation of the APA. And we would respectfully ask this court to reverse that order.
Thank you.
Thank you.
May it please the court. I'm Shaw Stiller, Chief Assistant General Counsel for Appalachia, Florida Office of Insurance Regulation. I will be presenting the argument this morning on behalf of the office. Splitting time with Mr. Volpe on behalf of citizens, I will endeavor to be seated with approximately 5 minutes left if consistent with the court's questioning. The office agrees with firm about the general principles applicable in Chapter 120. There are only 3 ingredients necessary for a formal administrative hearing: agency action, affecting substantial interest with disputed issues of material fact. Those are the only 3 ingredients in the recipe in the general setting. This is not the general setting. As Judge Weatherall said, the legislature wanted it done a certain way. Citizens is unique, and the process is unique. As Judge Thomas noted, in 2007, the legislature answered the question that's before the court today by amending the statute. To go back, that was a special session called in January of 2007 after the 04-05 storm seasons. As set forth in the office's brief, there were 2.8 million
Let me ask you
claims.
this. I mean, that history is interesting and potentially important, but we wouldn't get behind the language of the statute unless there's some ambiguity in it. And the language used by the legislature, the word used by the legislature, it tells the office to issue a final order. Do you agree with the appellant that final order, because it's not defined in the insurance code, we would look to Chapter 120, and in doing so, we would see that a final order is the end product of a proceeding that has a hearing involved in it under 120. Would you agree or disagree with that?
I would agree that final order as used in this provision in the insurance code mirrors and has the same implications as Chapter 120. As we cited in our brief in State versus Hearn, the Florida Supreme Court has made clear like words in statute should be given like interpretation. However, the definition of final order in 120.52.7 does not state that an agency must have a hearing in order to enter a final order. If that were the case, an agency could never dismiss a petition by final
Well,
order.
as I read the definition, it says a final order is a written decision that results from a proceeding under 56. Obviously, that's a rule challenge. That's not it. 565, that's a declaratory judgment. 569 or 57, which it could be. I mean, mediation, it's not. Summary final order, it's not. So, I mean, how did this order result from a proceeding under 569 or 57?
There was a request for a proceeding under 569 and 571, which was dismissed. And that dismissal is a final order, is, quote, final agency action, as used in Chapter 120.
Well, let's cut more towards the chase here, which is, I'm glad the appellants have asked us to focus on the heart of the matter here, which is whether parties can challenge the rates through a 120.57.1 hearing. I mean, that's what this appeal is all about, it seems to me. So it's your argument and the corporation's argument that, no, the policyholder has no legal right to challenge your office's decision setting the rates. If you set the rates at 9.9% every year, 9.9, 9.9, 9.9, which is permissible under the statute, no policyholder in the state of Florida has the right to say, you're not setting those, regarding the corporation, you're not setting those rates in accordance with state law that says it has to be non-discriminatory, it has to be affordable, the terms that the statute uses. That's what we have to say if we rule in your favor, right?
Yes, Your Honor, and we do believe that's the result the legislature inserted in the statute. It's worth.
Well, what about their argument where they say, well, the legislature said the corporation couldn't file for a hearing, but it didn't say the policyholders couldn't file?
The insertion of citizens not being able to file for an administrative hearing recognizes a bedrock 120 proceeding that an applicant, this court recognized it was in a case cited in the motion for fees in the Fort Myers Real Estate Holdings case, where this court said we are aware of no case where an applicant would not have a right to a formal hearing. It's the office's position that that's why the provision was inserted for citizens, to be sure it was clear, even with the term final order, given the due process, quite frankly, that attaches to an applicant's right to seek review. The legislature said no, and let
me ask this question, though. If final order means what you would like us to say that it means, that it's the culmination of the process, not subject to administrative challenge, how does the statute make sense by saying corporation may not pursue an administrative challenge? I mean, if it's final agency action, if that's what that word final order means, of course you couldn't have an administrative challenge because it's final agency action. How does that make sense then?
Again, it's the office's position that that's in recognition of the longstanding right of an applicant under any circumstances to seek review of an agency action affecting their rights.
Right, but if that would be like saying a disappointed permit applicant cannot seek administrative review of the DEP final order. That just doesn't make sense. You can seek review preliminarily of preliminary agency action, but if it's final agency, I mean, that's your argument, isn't it? The agency here, the office here, issues a final order, which is final agency action, not subject to 120 review. That's your position, right?
Correct.
So if that's the case, nobody could ever seek administrative challenge. It would have to be judicial review. I mean, am I missing something here?
No, that's correct. And again, the provision in there prohibiting administrative challenge, I would submit, is an abundance of caution given the case law specific to applicants.
And I think the language is pretty clear. Seems to me the language is pretty clear. Citizens doesn't have a right to challenge the rate decision. It says right in the statute, citizens may not challenge it. That's as crystal clear as I can imagine the legislature can be. But I want to go back to my question, which is, if we rule in your favor, if we write an opinion that the firm, that the policyholder does not have the right to challenge the rates, I want to ask you again, you've said it already, but that means that your office and the corporation could increase the rates 9.9% every year, year in, year out, and maybe have a hearing and say, you know what, we've got these criteria we're supposed to manage by. I'm not implying that you would act in bad faith, but I'm just saying, to decide the parameters of the ruling, no policyholder has a right to challenge that decision-making process through a 120-57-1 hearing.
That's correct. And there are two things to point out here. Annually, Citizens comes in. An examination of the legislative history of the Citizens statute will show that the legislature reviews the decision every year. This statute is opened every year and is revised, specifically the Citizens paragraph, almost every year.
Well, but that's not provided in the statute. The statute says Citizens comes in every year. As I mentioned earlier, they have to file for the rating. They have to submit information, request. They might ask for a rate decrease. I don't know. But they submit information to your office, and every year it's changed. The legislature may or may not take a look at that.
They may or may not, but history shows they have.
Well, I know, but that's not part of the statutory procedure. And again, your argument is the policyholders have no right to an administrative challenge.
They do not. And again, to get back to some of the unique features of Citizens that mandates this, after the 2004-2005 season, not only was the statute changed, but even given Citizens having some of the most expensive rates in the state, there was still an $887 million deficit.
Let me I'm sorry.
Go ahead, Judge.
With Judge Weatherall's earlier question, if you take this outside of the context of Citizens and you have a private insurer who, as I understand it, would make a request to OIR to set rates a certain way, and then OIR would approve them, is that the process right so far?
Under 062, the rates are submitted, and if the office disapproves, we give a notice of disapproval.
Okay, and would a private insurance consumer, a homeowner or whatever, have an administrative right to challenge that decision, to approve or reject it? That's basically Judge Weatherall's question from earlier, and maybe you can help us with it.
The discussion of standing in our brief, I think the answer is no. Generally, I don't think the office's position is that an individual policyholder would not have the type of substantial interest to invoke a 120 proceeding. And again, the mechanics of every rate filing being subject to a 120 proceeding would mean that rate filings would generally or may lag a year behind. It's also very telling, this is discussed on page 29 of our brief, there are no reported cases of ratepayers filing petitions and going to DOA. There's one
Let me ask you
reported
this. I know you're eating into your co-counsel's time, but this other statute that is implicated here, 627-371, which I guess they've now essentially conceded, it deals with the application of the rates, which doesn't seem to be where we are. But I guess what confuses me is that the preliminary agency action that the office takes there is a determination of probable cause or no probable cause, correct?
Correct.
And so but you gave them 120 rights at that point to demonstrate something. I mean, didn't you give them a 120 notice at that point with respect to the probable cause determination?
They were given, an order was entered, Judge Weatherall, giving them the opportunity to present additional legal argument to the office. To support.
And then you gave them an informal hearing under 57-2, right?
It was correct.
But I guess so the culmination of that informal hearing would have been, I mean, again, as I understand the 120 administrative hearing process, it gives substantially affected parties, people whose substantial interests are affected, an opportunity to change the agency's mind. And so the culmination of that process wouldn't be a determination on the merits. It would simply be a determination by the office that, oh, you've convinced us through your additional submittals that there's probable cause for us then to take the next step, correct?
Correct, and the next step would be to ask the insurer, is this correct, and give the insurer the opportunity to correct. It's important to note that in 371, it's not only the insurance as applied to the person making the complaint, but it's the rate, quote, made by the insurer. And so 371, as a matter of law, doesn't apply to Citizens because the office makes the rates.
It just, to me, is a very odd point in time to give somebody 120 rights. It would almost be as if in a disciplinary case, it was the board making the probable cause determination. If a complainant goes in, says my accountant messed up and violated the statute, submits a complaint to the accountancy board, the board says, we find no probable cause, we're not doing anything. I've never seen that those people get a right to try to convince the agency that there was probable cause. And if the agency determines there's probable cause, then the subsequent proceedings have nothing to do with the complaint. They're not involved in that at all. It's you versus Citizens. So it's just a bizarre place to give them 120 rights, for what it's worth.
Your Honor,
I'm going to give you your partner an additional 2 minutes, and Madam Clerk will give the appellant an additional 2 minutes.
Thank you, Your Honor. May it please the court. My name is Tim Volpe of the law firm of Adams Reese. I have with me at council table Mr. Tom White and a representative of Citizens, Mr. Mark Castile, here with me today. As time is short, I'll try, as you have suggested, Your Honor, Judge Thomas, to get to the nub of it. I'm fascinated with today's apparent concession that this case doesn't involve 627-371, as Judge Weatherall has asked about. That was, in fact, it is, in fact, precisely how this case was commenced. And I think it's undeniable that, and I appreciate the concession of counsel, that this is only applicable to the application of rates. Every single verb in section 627-371 is past tense. And this court has been very clear that when the legislature uses past tense words, they mean what they say. They're presumed to understand the rules of grammar. And so in this instance, the claim that has been made, not the claim that they perhaps want to make, but the claim that has been made under 627-371 is absolutely inapplicable here. They are pursuing a rate dispute with respect and under a statute that deals with the application of rates already in effect. And in this instance, the timeline makes very clear.
Was there not a separate denial of their request for a hearing to challenge the rate final order itself?
Well, that's not the premise that they have operated under. I'm not certain if that's true or not. The first entry that we had into this matter was a request under section 627-371, which, as I think your honors have pointed out, is sort of the entry point, a claim being made by a policyholder that the application of a rate is inappropriate for whatever reason. And so as we responded to that, we made it clear, as Judge Thomas has said.
I'm reading on page 5 and 6 of the final order, where firms request for administrative hearing on the rate orders, and the office is saying that the rate orders are final orders that aren't subject to APA review. Therefore, the hearing on the rate orders is dismissed. I mean, so in fact, the answer to my question was yes.
I suppose so, under the circumstances.
You suppose so.
Well, no, I mean, I'm acknowledging that that's the case. I'm not disputing what you're saying, Judge. I'm simply saying that from the citizens' perspective, our entree point into this was under 371. And that's the part that makes very little sense to us, because as Judge Thomas suggested, this process is intended to be truncated. Citizens has to be the lowest cost provider of insurance, must be, and under the and by law. And under the circumstances, from our perspective at least, we couldn't understand how it is that there could be a challenge to a rate filing predicated on 371 because we don't make the rate. The rate is established by the Department of Insurance. And so the plain meaning of the statute
That's
from
what
our
they're
perspective.
challenging. I mean, I understand, I think I understand that Citizens is kind of a quasi-governmental entity, but what they're here on is challenging the decision of the office to approve your rates.
Right.
And they're saying, as I understand their argument, is that that approval of a rate, while the statute uses the word final order, that's a term of art that cannot happen until a 120 process runs its course. I understand the counter arguments that it couldn't run its course given the compressed time frame, but that's
Right.
what we're here about.
Right. Well, and in fact, that's the case. The practical component of this, in addition to the plain language, the practical component is there would be no way to ever have a rate that we could use. And I would only take issue with one comment that you made, Your Honor, and that is you said that they approve the rate. They don't approve it, they establish it. Could be higher, could be lower. When an ordinary insurance company makes a rate filing, and I do these fairly routinely, they say, here's what we propose as our rates, and that can either be approved or disapproved. That's it. In this instance, the Department of Insurance establishes the rate.
Fair enough.
Thank you, Counselor.
Thank you, Your Honors. A few things that I'd like to respond to here. First of all, the order at record 418 clearly states that the office is denying firm's petition for formal administrative hearing. You can find the heading.
That's on the rate.
That's on the record.
Right. No, I mean, that's on the setting the rate. They
Yes.
denied you a hearing on the rate. They gave you a 57-2 hearing on the probable cause letter, right?
Correct, Your Honor. They denied our petition for formal administrative hearing.
Your argument here is that policyholders can come in every year and say, we don't like the rate set by OIR for citizens. We want a hearing to argue it's not affordable, that you should use our hurricane model, not theirs, that, you know, there are reasons why Monroe County is unlikely to get a hurricane under our model. And every year, that rate can be challenged in an administrative hearing, requiring a final order, allowing a direct appeal to this court. That process could take 1 year, 2 years, and every year, that process can be challenged by a single policyholder.
Your Honor, that's what
That's
the law.
your argument, right?
That's what the law says. Yes, Your Honor.
We'll decide that. That's your argument, though, right?
Yes, Your Honor. The corporation may be unique under the insurance code, but it is not unique under the Administrative Procedure Act. It's not unique under 120.
But isn't it a unique
This isn't
creature?
about the corporation, though. This isn't whether the corporation is unique. It's the office.
And the
That's
office
where I
is-
think this side of the room is a little bit confused about who's at issue here. We're looking at the office's action.
That's correct, Your Honor. And it's the
And
office.
isn't the office's action on citizens maybe not unique, but different from the office's action on private insurers?
It sure is, Your Honor, but it's not made unique under the Administrative Procedure Act.
But you're asking us to make it unique in the sense that you're saying a citizens policyholder could challenge OIR's decision on rates, but a State Farm policyholder could not challenge OIR's decision as to whether to approve or reject State Farm's proposed rates, right?
Well, Your Honor, a private insured could pick another insurer. The reason that
But that's a different fee. So you're acknowledging that a private insurer could not go in and challenge OIR's decision to approve XYZ insurance company's rates, just citizens, right?
Your Honor, my argument is that they can challenge citizens' insurance rates. I don't have a full and complete understanding of what the avenues of review are for a private insured.
Okay, fair enough. But you're not here saying that they could.
Right. There are standards.
Do you think that's the legislative scheme? That a single policyholder can come in every year and challenge citizens, the office setting of a citizen's rate? Isn't it a creature designed to provide insurance where no private insurer will provide insurance?
It is. It's a creature designed to create the insurer of last resort in areas where insurance is not otherwise available. And, Your Honor, an individual single.
For a second. If, Mr. Stiller and I had this conversation, I don't know if we ever came to a resolution of it, but the 6N1 talks about issuing a final order, and then the next sentence says that citizens may not pursue an administrative challenge or judicial review of the final order.
Yes, Your Honor.
That sentence, from an APA mind, makes no sense to me, because if it's a final order, your only opportunity for review is judicial review. If it's not a final order, if final order means final agency action, your only opportunity to review is judicial. If final order means something other than final agency action, then your only opportunity is administrative challenge. So don't we have an ambiguity in the statute that would allow us then to look at the legislative history, look at what the statute said before, and conclude that it must mean something different now?
Your Honor, I think that it is less than entirely clear. However, the rules of statutory construction tell us that when the legislature expresses one thing, that's to the exclusion of its alternatives. The legislature knows how to exempt an agency.
Feel free to take 25 more seconds, like Mr. Volpe did.
Thank you. The legislature knows how to exempt OIR's final agency actions from the APA. It didn't do so in this case. The legislature knows how to bar people from challenging and seeking administrative review of agency action. It didn't do so in terms of firms' petition in this case. The interpretation propounded by the appellees, it defies 40 years of well-established legal principles. A private insured could pick another insurer, but policyholders of Citizens are holders of policies issued by the insurer of last resort. And without the opportunity to seek review, independent third-party review of the orders establishing those rates, there's no check, no oversight over this governmental action. And that's not what the law says. The law says the public is guaranteed. Thank you.
We'll ask the parties in the next case to allow the attorneys a chance to disembark.